à présent le quatrième.
We will now examine the fourth ground of appeal of the prosecution. The trial chamber committed an error of fact by concluding that, for the purposes of Article 7.3 of the statute, Krnojelac did not have sufficient information to put him on notice that his subordinates were involved in the murder of detainees at the KP Dom. The prosecutor states that given the factual findings accepted by the trial chamber, the only reasonable finding open to the said chamber was that Krnojelac had sufficient information to put him on notice that his subordinates might be involved in the murder of detainees. As with the previous ground of appeal, the appeals chamber recalled the relevant facts accepted by the trial chamber with regard to the murders. The appeals chamber holds that a certain number of facts constituted sufficiently alarming information to have required Krnojelac to carry out an additional investigation. Being aware of the beatings and the suspicious disappearances, and having seen the bullet impacts in the walls, Krnojelac was in a position to reflect that the perpetrators of these beatings were likely to have committed murders. He should at the very least have carried out an investigation. The appeals chamber considers that no reasonable trier of fact could have reached the factual findings of the trial chamber. The appeals chamber holds, therefore, that the trial chamber committed an error of fact and that, for the reasons set out above, this resulted in a miscarriage of justice. We will now examine the fifth ground of appeal of the prosecution. The trial chamber erred, in fact, by concluding that the beatings constituting inhumane acts and cruel treatment were not inflicted on discriminatory grounds, and that, therefore, Krnojelac could not be held responsible for persecution as superior. The prosecutor submits that the trial chamber erred in concluding that the beatings constituting inhumane acts and cruel treatment inflicted by the guards on detainees at the KP Dom were not carried out on discriminatory grounds, and that they did not therefore constitute persecution for which Krnojelac could be responsible under Article 7.3 of the statute. The appeals chamber recalls that in law, persecution as a crime against humanity requires proof of specific intent to discriminate on political, racial, or religious grounds, and that it falls to the prosecutor to prove that the acts in question were committed with the requisite discriminatory intent. The appeals chamber does not consider that the discriminatory intent of the beatings can be inferred directly from the general discriminatory nature of an attack characterized as a crime against humanity. According to the appeals chamber, such a context is not in itself proof of discriminatory intent. The appeals chamber does hold, however, that discriminatory intent may be inferred from such a context, provided that, with respect to the facts of the case, there are circumstances surrounding the commission of the acts charged which confirm the existence of such intent. These circumstances may include, for example, the functioning of the prison, in particular the systematic nature of the crimes committed against a racial or religious group, or the general attitude of the alleged perpetrator of the offense through his behavior. In this case, the trial chamber indicated that the, and I quote, detention of non-Serbs in the KP Dom and the acts or omissions which took place therein were clearly related to the widespread and systematic attack against the non-Serb civilian population in the Foča municipality. End of quote. The appeals chamber holds that one can infer from this finding that the treatment inflicted on the non-Serb detainees is the result of the aforesaid discriminatory policy, which was the cause of their detention. There still need to be circumstances surrounding the commission of the acts charge which confirm this initial inference. In this case, it emerges from the trial chamber's findings that, in reality, only the non-Serb detainees were beaten. The appeals chamber holds that the difference in the treatment of the Serb and non-Serb detainees cannot reasonably be attributed to the guards' random assignment. This finding confirms the aforesaid inference. Thus, the appeals chamber considers that the only reasonable finding to be made, on the basis of the relevant facts accepted by the trial chamber, was that the beatings were inflicted on the non-Serb detainees for political or religious reasons, and that, consequently, these unlawful acts were committed with the requisite discriminatory intent. The appeals chamber considers that, assuming that the blows inflicted on the non-Serb detainees were meted out to punish them for a violation of the rules, the choice of that punishment, if inflicted only on non-Serb detainees, arose from a wish to discriminate against them on religious or political grounds. The prosecutor maintains that Krnojelac should be found guilty of persecution under Article 7.3 of the statute. The appeals chamber recalls that the trial chamber acknowledged that Krnojelac freely accepted the position in full knowledge of the fact that non-Serb civilians were being unlawfully detained at the KP Dom on the basis of their ethnicity. Furthermore, Krnojelac accepted that he knew that the non-Serbs were being detained precisely because they were non-Serbs, and that none of the procedures in place for legally detained persons were followed at the KP Dom. The trial chamber acknowledged that Krnojelac knew that Muslim detainees were being beaten and generally mistreated. He, and I quote, I'm quoting from the judgment, he knew about the conditions of the non-Serb detainees, the beatings and other mistreatment to which they were subjected while being detained at the KP Dom, and he knew that the mistreatment which occurred at the KP Dom was part of the attack upon the non-Serb population of Foča town and municipality. In view of all the elements set out above, the appeals chamber considers that Krnojelac, who, as prison warden, retained authority over all detainees in the KP Dom, had sufficient information to put him on notice that inhumane acts and cruel treatment were being inflicted on the non-Serb detainees on political or religious grounds. The appeals chamber concludes, therefore, that the trial chamber committed an error of fact, which resulted in a miscarriage of justice. We will now turn to the prosecution's sixth ground of appeal. The trial chamber erred by acquitting Krnojelac on the count of persecutions based on forced labor. In support of this ground of appeal, the prosecutor submitted that the trial chamber erred by finding that there was insufficient evidence to establish the involuntary nature of the labor. She maintained that in applying the legal test for involuntariness to the facts, the trial chamber erroneously determined for 8 detainees that the evidence produced was insufficient to conclude that they had been forced to work. Here again, the appeals chamber has summed up the relevant facts accepted by the trial chamber. We will not go over them again, you will find them in the written judgment. The appeals chamber repeats that the living conditions at the KP Dom were clearly deplorable. Of the facts previously summed up, some are especially significant and must be emphasized. The trial chamber concluded that within the KP Dom there was a deliberate policy to feed the non-Serb detainees barely enough for their survival. All non-Serb detainees suffered considerable weight loss ranging from 20 to 40 kilograms during their detention at the KP Dom. Additionally, the non-Serb detainees were locked up in their rooms for most of the day, being allowed out only to go to the canteen. Some, however, were taken out to work, knowing that they would receive additional and much-needed food if they did. Finally, the non-Serb detainees were subjected to harrowing psychological abuse during their period of detention at the KP Dom. The detainees were exposed to the sounds of people being beaten and tortured over a period of months, in particular in June and July 1992, and they constantly feared that they would be the next to be selected. The appeals chamber considers that in view of the particular detention conditions of the non-Serb detainees at the KP Dom, a reasonable trier of fact should have reached the conclusion that the detainees' general situation negated any possibility of free consent. The appeals chamber is satisfied that the detainees worked in order to avoid being beaten or in the hope of obtaining additional food. Those who refused to work did so out of fear. given the disappearance of detainees who had gone outside the KP Dom. The climate of fear made it impossible to express free consent. A detainee cannot be expected to raise an objection. Nor can it be held that for forced labor to be established, a person in a position of authority must threaten to punish a detainee if he refuses to work. The fact that a detainee may have objected is irrelevant if the possibility of objecting is not a real option. In the view of the appeals chamber, the specific circumstances of the KP Dom detainee's life in prison were therefore such as to make free consent impossible. Consequently, the appeals chamber sets aside the trial chamber's findings in respect of witnesses FWS 249, FWS 144, Rasim Taranin, FWS 66, FWS 198, Ekrem Zekovic, Muhammad Lisica, and FWS 71, and reaches the conclusion that these witnesses were forced to work. The prosecutor, secondly, contended that if forced labor were to be established, the trial chamber's findings were sufficient to warrant Krnojelac conviction for persecution based on forced labor. On this point, the appeals chamber states that the acts underlying the crime of persecution, whether taken in isolation or in conjunction with others, must constitute a crime of persecution of equal gravity to the crimes enumerated under Article 5 of the statute. It maintained that, in the case in point, the forced labor must be considered as part of a series of acts comprising unlawful detention and beatings, the cumulative effect of which is of sufficient gravity to amount to a crime of persecution, it being understood that the unlawful detention and beatings were committed on one or more of the discriminatory grounds listed under Article 5 of the statute. Accordingly, the degree of gravity of the persecution based on these acts amounts to that of the crimes expressly set out under Article 5 of the statute. The appeals chamber has previously recalled that in this instance the trial chamber indicated, and I quote, that the detention of non-Serbs in the KP Dom and the acts or omissions which took place therein were clearly related to the widespread and systematic attack against the non-Serb civilian population in Foča municipality. The appeals chamber had also previously pointed out that it could be inferred from this backdrop that the treatment meted out upon the non-Serb detainees was the result of the aforementioned discriminatory policy which led to their detention, on the condition that, as regards the facts of the case, there were circumstances surrounding the commission of the acts of forced labor which confirm the existence of such intent. In the view of the appeals chamber, there is no doubt that, in this instance, the non-Serb prisoners were detained and forced to work on account of their ethnicity. The trial chamber understood that, and I quote, the few Serb convicts who were detained at the KP Dom were kept in a different part of the building from the non-Serbs. They were not mistreated like the non-Serb detainees. The quality and quantity of their food was somewhat better, sometimes including additional servings. They were not beaten or otherwise abused. They were not locked up in their rooms. They were released once they had served their time. They had access to hygienic facilities and enjoyed other benefits which were denied to non-Serb detainees. End of quote from the judgment. It is clear that the non-Serb detainees were, on the other hand, subjected to a quite different regime. The overcrowding of the solitary confinement cells, in which the detainees were so crammed that they were unable to move around or lie down, the undernourishment and its principal effects in terms of weight loss, the widespread nature of the beatings and mistreatment, and the psychological abuse linked to the detention conditions and the mistreatment constitute circumstances particularly indicative of the discriminatory character of the acts of forced labor imposed upon the non-Serb detainees. In the opinion of the appeals chamber, the trial chamber was misled by its case-by-case approach to each of the acts of forced labor and consequently failed to consider all of the circumstances surrounding the commission of the acts. circumstances which, in this instance, confirm that the said acts did indeed fit into the discriminatory context at the KP Don, as did the unlawful detention and the beatings that were committed. The appeals chamber thus finds that, in view of the circumstances, no reasonable trier of fact would have failed to conclude that the acts of forced labor were committed with discriminatory intent. The appeals chamber is in no doubt that the 8 detainees forced to work were the victims of persecutions within the meaning of Article 5 of the statute. With the persecution based on forced labor established, the appeals chamber next considered Krnojelac responsibility for these crimes. The appeals chamber has previously stated that in the case in point, the alleged crime of forced labor should be dealt with as forming part of a first category joint criminal enterprise, without use being made of the system notion, and that the persons who participated in its commission may be viewed as co-perpetrators of a joint criminal enterprise whose purpose was to commit the crime in question, or as aiders and abettors thereto, depending on whether, as in the first instance, the individual concerned shared the common intent, or, as in the second, merely had knowledge thereof. On this point, the appeals chamber takes the view that Krnojelac must not be regarded as a mere aider and abettor, but as a co-perpetrator of the crimes of forced labor which were committed. The appeals chamber believes that Krnojelac shared the intent to make the non-Serb detainees perform unlawful labor in conditions which the appeals chamber found to be such that it was impossible for them to consent freely to work. The appeals chamber holds that the only conclusion which a reasonable trier of fact should have reached is that Krnojelac was guilty as a co-perpetrator of persecutions based on the forced labor of the non-Serb detainees for the following reasons. Krnojelac was aware of the initial decision to use KP Dom detainees to work. He was responsible for all the business units and work sites associated with the prison, and he played a central role in the matter. Moreover, Krnojelac voluntarily accepted the position, in full awareness that non-Serb civilians were being illegally detained at the KP Dom because of their ethnicity, and he also knew that none of the procedures in place for legally detained persons was ever followed with the non-Serbs at the KP Dom. He exercised final control of the work of detainees in and for the KP Dom. He had regular meetings with the heads of the furniture factory, metal workshop and farm where the detainees worked. It is the appeals chamber's opinion that, in light of the foregoing, it is not possible that Krnojelac did not share the intent to use unlawfully detained non-Serbs to work. The appeals chamber therefore finds that the trial chamber's decision to acquit Krnojelac of the crime of persecution based on forced labor must be reversed, and that, on the basis of Article 7.1 of the statute, Krnojelac must be convicted of persecution based on forced labor as a co-perpetrator of the joint criminal enterprise whose purpose was to persecute the non-Serb detainees by exploiting their forced labor.
The appeals chamber will now turn to the 7th ground of appeal. The trial chamber erred by acquitting Krnojelac on the count of persecutions, deportation. This ground of appeal concerns the trial chamber's findings on the first count of the indictment. Persecutions based on, quote, deportation and expulsion, unquote. The quotes are particularly important. First of all, I shall look into the persecutions. In support of this ground, the prosecutor principally argued that the trial chamber had erred in the definition of deportation and to some extent the definition of expulsion. The appeals chamber does not believe that, in the circumstances of this case, the main issue is the definition of these terms. The appeals chamber emphasizes that, as regards the indictment submitted by the prosecutor, the subject of the discussions before the trial chamber was persecution, and the appeals chamber therefore holds that 2 issues arise out of the prosecutor's submissions. A, whether the trial chamber correctly construed the allegations of persecution in the indictment, and B, whether the acts of displacement admitted by the Chamber are such as to possibly constitute crimes underlying persecutions. In the indictment, Krnojelac is charged with persecutions, punishable under Article 5H of the statute for acts of deportation and expulsion. He is not separately charged with deportation as a crime against humanity. The appeals chamber is of the view that while the wording used in the indictment was not best suited, it did not contain any ambiguity as to the fact that Krnojelac was being prosecuted for having perpetrated the crime of persecution by means of forcible displacements within and across the borders of Bosnia and Herzegovina. The appeals chamber is of the view that there is no need to rule on the definition the trial chamber gave to the terms deportation and expulsion, either for the purposes of setting aside or upholding that definition. The issue raised in this instance was whether the alleged acts of forcible displacement could constitute a crime of persecution, assuming that they were committed with discriminatory intent. The appeals chamber notes that the terms deportation and expulsion under paragraph 5(2)(f) of the indictment were clearly used by the prosecutor as a generic term embracing all the forms of conduct alleged in this instance to underlie the crime of persecution. No reference was made in the indictment to deportation under Article 5D of the statute. As such, there is no need to define a term which does not appear in the provision on which the indictment relies. The appeals chamber holds that the trial chamber was bound to make a ruling on the material facts alleged and to assess whether these acts constituted persecutions within the meaning of Article 5H of the statute. The appeals chamber has examined which acts of displacement may constitute persecutions when perpetrated with the requisite discriminatory intent, and whether the acts alleged by the prosecutor were indeed such as to constitute acts underlying the crime of persecution. The appeals chamber considers that the acts of forcible displacement underlying the crime of persecutions punishable under Article 5H of the statute are not restricted to displacements across a national border. The appeals chamber believes that the crime of persecutions may take various forms. It may be one of the other acts constitutive of crimes under Article 5 of the statute, or one of the acts constitutive of crimes under the other articles of the statute. In order for it to be possible for these acts to be viewed as underlying the crime of persecution, they must separately or cumulatively be committed with discriminatory intent and constitute a crime of persecution of equal gravity to the other crimes under Article 5 of the statute. The appeals chamber concludes that displacements within a country or across a national border committed on grounds not authorized by international law are crimes punishable in customary international law, and that such acts, if committed with the requisite discriminatory intent, do constitute the crime of persecution under Article 5H of the statute. The appeals chamber holds that the facts found by the trial chamber fall into the category of displacements, which may constitute persecutions. The appeals chamber notes that by failing to determine whether the alleged acts of forcible displacement constituted persecutions, the trial chamber committed an error of law which renders its decision void. The prosecutor could, when it held that the 35 non-Serb detainees from the KP Dom taken across the border to Montenegro freely chose to be exchanged. She submitted that the trial chamber was mistaken in not taking account of the regime of coercion to which the KP Dom detainees were subjected. The appeals chamber observes that the living conditions at the KP Dom subjected the non-Serbs detainees to a coercive prison regime which was such that they were unable to make a true choice. The appeals chamber accordingly concludes that the 35 detainees were subjected to duress and that the trial chamber was mistaken in finding that they had freely chosen to be exchanged. The prosecutor further argued that no trial chamber could have reasonably concluded that it had not been shown that the transfer of the 35 detainees to Montenegro had been carried out on the requisite discriminatory grounds. The prosecutor makes general reference back to the arguments pleaded in support of her fifth ground of appeal, and notably to the climate of systematic violence and discrimination in which the KP-DOM detainees lived because of their ethnicity. Given these findings, as well as the discriminatory character of the unlawful imprisonment and the infliction upon the non-Serb detainees at the KP-DOM of living conditions as described above, the appeals chamber makes the finding that it was unreasonable for the trial chamber to conclude that there was no evidence that the transfer of the 35 detainees to Montenegro had been carried out on the requisite discriminatory grounds. The appeals chamber considers that the reasoning used in order to establish that the 35 non-Serb detainees were forcibly displaced to Montenegro applies mutatis mutandis to the other displacements found by the trial chamber. The same holds for Krnojelac discriminatory intent. Now shall now look at Krnojelac responsibility. The prosecutor maintained that the trial chamber erred when it held that Krnojelac was not responsible for the displacement of detainees within Bosnia and Herzegovina, with which he was charged under count 1, persecution, and that the acquittal should be reversed. In addition, she contended that the trial chamber erred by finding Krnojelac not guilty pursuant to Article 7.1 of the Statute of the transfer of the 35 non-Serb detainees to Montenegro and of other non-Serb detainees to other locations in Bosnia and Herzegovina. The appeals chamber is satisfied that the KP-DOM administration carried out the orders of the military authorities and that the KP-DOM guards handed over the detainees for transfer. It is not, however, satisfied that Krnojelac had the power to influence which detainees were to be displaced. There is evidence that Krnojelac tried, without success, to assist witness R.J., who wanted to be exchanged, and that he believed he was assisting him to gain security and rejoin his family. The prosecutor further submitted that Krnojelac knew that the transport of detainees was problematic, and that he had reason to ensure the safety of the detainees after they left the compound. The appeals chamber considers that Krnojelac was aware of the consequences of the transport of the detainees, but that he played no role therein. This, notwithstanding, Krnojelac is criminally and individually responsible for the exchanges, which form part of the joint criminal enterprise in which he personally played a role in the ultimate aim of achieving the forcible displacement of the detainees under his control at the KP-DOM. As a result, it need not be proven that he personally took part in drawing up the lists. The exchanges began in the summer of 1992 and continued until March 1993 at least. As already stated, the appeals chamber is satisfied that the non-Serb detainees were taken out of the KP-DOM with discriminatory intent. According to his own testimony, Krnojelac knew that the detainees were being taken out of the KP-DOM. Furthermore, the trial chamber established that by virtue of his position as warden of the KP-DOM, Krnojelac knew that the non-Serb detainees were being unlawfully detained on account of their ethnicity. In his capacity as warden, Krnojelac authorized the KP-DOM personnel to hand over non-Serb detainees. He encouraged such departures by allowing them to continue. Without the unlawful imprisonment, it would not have been possible to continue with the exchanges. The appeals chamber is satisfied that Krnojelac shared the intent of the principal perpetrators of the joint criminal enterprise, whose purpose was to take the non-Serb detainees out of the KP-DOM. The appeals chamber therefore considers that Krnojelac is responsible as a co-perpetrator for persecutions which took the form of forcible displacements as alleged by the prosecutor under deportation and expulsion. Let's now turn to the sentence. In the present case, both parties raised grounds of appeal relating to the 7.5-year sentence imposed by the trial chamber. The appeals chamber has examined the various grounds of appeal by applying the standard of review for alleged errors as settled in its jurisprudence. The appeals chamber dismissed all of the grounds of appeal raised by the parties with the exception of one of the prosecutor's grounds. The prosecutor challenged the weight which the trial chamber gave in mitigating of sentence to the cooperation provided by the tribunal and prosecution by the defense. and not Krnojelac. According to the prosecutor, the efficient and cooperative conduct of defense counsel cannot be a mitigating factor warranting a reduced sentence for the accused, any more than the inefficient or uncooperative conduct of counsel may be considered an aggravating factor warranting an increased sentence. The appeals chamber finds that the conduct described in the contested paragraph of the judgment is the normal conduct that any counsel should adopt before a trial chamber. The appeal chamber therefore considers that the trial chamber committed an error by giving credit to the accused for the conduct of his counsel. The appeals chamber concludes that the commission of its error means, as previously indicated, that the conduct of counsel for Krnojelac must not be taken into consideration in determining the sentence imposed on the basis of the new convictions on appeal. The appeals chamber shall now determine the sentence having regard for the new convictions pronounced on appeal. The prosecutor requested that, if the appeals chamber reversed one or more of the acquittals, the sentence be increased commensurably. She submitted that it was possible for the appeals chamber to revise the sentence itself rather than remit the matter to the trial chamber. This assertion was not contested by Krnojelac and is accepted by the appeals chamber. Having given due consideration to the gravity of the crimes and Krnojelac's responsibility as established by the trial chamber, and taking into account Krnojelac's responsibility established on the basis of the new convictions on appeal, the appeals chamber has revised the sentence in the exercise of its discretion and in the light of the mitigating and aggravating circumstances taken into consideration. Mr. Krnojelac, I shall ask you now to stand so that you can hear the disposition that will be read out. The appeals chamber, pursuant to Article 25 of the statutes and Rules 117 and 118 of the rules, noting the respective written submissions of the parties and the arguments they presented at the hearing of the 14th and 15th of May 2003, sitting in open session, allows the prosecutor's first ground of appeal and sets aside Krnojelac's convictions as an aider and abettor to the persecutions, crime against humanity, for imprisonment and inhumane acts and cruel treatment, violations of the laws or customs of war for the living conditions imposed under counts 1 and 15 of the indictment pursuant to Article 7.1 of the statute, allows the prosecutor's third ground of appeal and reverses Krnojelac's acquittal on counts 2 and 4 of the indictment, torture as a crime against humanity and violations of the law or customs of war, pursuant to Article 7.3 of the statute, allows the prosecutor's fourth ground of appeal and reverses Krnojelac's acquittal on counts 8 and 10 of the indictment. Murder as a crime against humanity and murder as a violation of the laws or customs of war, pursuant to Article 7.3 of the statute, allows the prosecutor's fifth ground of appeal for the revision of Krnojelac's conviction on count 1 of the indictment, persecution as a crime against humanity, pursuant to Article 7.3 of the statute, so that it encompasses a number of beatings, allows the prosecutor's sixth ground of appeal and reverses Krnojelac's acquittal on count 1 of the indictment, persecution as a crime against humanity, based on the forced labor imposed upon the non-Serb detainees, allows the prosecutor's seventh ground of appeal and reverses Krnojelac's acquittal on count 1 of the indictment, persecution as a crime against humanity, based on the deportation and expulsion of non-Serb detainees, dismisses the prosecutor's second ground of appeal on the form of the indictment, dismisses all of the grounds of appeal raised by Krnojelac, finds Krnojelac guilty of counts 1 and 15 of the indictment as a co-perpetrator of persecution, a crime against humanity, imprisonment and inhumane acts, and of cruel treatment, a violation of the laws or customs of war for the living conditions imposed pursuant to Article 7.1 of the statute, fines Krnojelac guilty of counts 2 and 4 of the indictment, torture as a crime against humanity and violations of the law or customs of war pursuant to Article 7.3 of the statute, based on the following facts: paragraph 5.21 for FWS 73, paragraph 5.23, except for FW 303, paragraph 5.27 for Nurko Nisic and Zulfu Vez, 528 and 529 for Aziz Sahinovic of the indictment, and facts described under points B4, B14, B22, B31, B52, and B57 of the list C of the indictment. Finds Krnojelac guilty of counts 8 and 10 of the indictment, murder as a crime against humanity, and murder as violations of the laws or customs of war, pursuant to Article 7.3 of the statute. Revises Krnojelac conviction under count 1 of the indictment, persecutions as a crime against humanity, pursuant to Article 7.3, so that it encompasses the beatings described in paragraph 5.9, 5.16, 5.18, 5.20, 5.21 for FWS 110, FWS 144, Mohamed Lisica and several other unidentified detainees, 5.27 for Salim Bicho and 5.29 for Haida Jemal, Enes Uzunovic and Elvedin Cedic of the indictment, and in the facts corresponding to numbers A2, A7, A10, A12, B15, B17, B18, B19, B20, B21, B25, B26, B28, B30, B33, B34, B37, B45, B46, B48, B51, and B59 of List C of the indictment. Finds Krnojelac guilty of count 1 of the indictment as a co-perpetrator of the crime against humanity of persecutions, forced labor, deportation and expulsion pursuant to Article 7.1 of the statute. Sets aside all of the convictions entered under count 5 of the indictment, inhumane acts as crimes against humanity pursuant to Article 7.3 of the statute, and the convictions entered under count 7 of the indictment, cruel treatment as a violation of the laws or customs of war pursuant to Article 7.3 of the statutes, based on the following facts: paragraph 5.21 for FWS 73, 523, 5.27 for Nurko Nisic and Zulfu Vez, 5.28 and 5.29 for Aziz Sahinovic of the indictment, and facts described under points B4, B14, B22, B31, B52, and B57 of List C of the indictment. Dismisses the sentencing appeals entered by Krnojelac and the prosecutor, with the exception of the ground of appeal allowed in paragraph 262 of this judgment, and determines a new sentence, having regard for Krnojelac responsibility established on the basis of the new convictions on appeal and in the exercise of its discretion. Sentences Krnojelac to 15 years imprisonment to run as of this day, subject to credit being given under Rule 101C of the rules for the period Krnojelac has already spent in detention, that is, from the 15th of June 1998 to the present day. This appeals judgment has been drafted in English and in French, the English being authoritative in the presence of Judge Mohamed Shaboudine, Judges Mehmed Gune and Judge Kamal Ajus and I, and myself. I would like to state that Judges Shaboudine have the judges Schomburg and Shahabuddin each append a separate opinion to the appeals judgment, done this 17th day of September 2003 at The Hague.
All rise, we will lever.